Hi everyone, welcome to my channel Andy on Crime, where I look at high profile criminal cases and other aspects of criminal law in England and Wales. As we enter the start of political campaigning before the next general election, you may have seen articles such as this from the Telegraph and other newspapers about Keir Starmer and the work that he did as a criminal barrister before becoming an MP. Now, the Telegraph has taken a look at some of the people that Keir Starmer has represented over the course of his career. And in one sentence, the article talks about how in the vast majority of cases, he has acted for killers, sex offenders, and terror suspects. This being suggested as some sort of revelation that someone appointed as a King's Counsel, the most senior, experienced and capable barristers in England and Wales, it's somehow a surprise that he has acted in the most serious cases. And the article itself suggests that Starmer is as much to blame as the person who he acted for, which I think frankly is a disgraceful comment. Now, before I go any further, I want to make clear that this video is not a political one. I'd be making the same defence of Alex Chalk, the Justice Secretary, or any other politician who has been a member of the criminal bar before becoming an MP. The point here is that we should not demonise barristers who are being required to act for anyone regardless of what the offence they are alleged to have committed, or post-conviction where there is an arguable case for them to act upon. We should instead be happy that anyone, even people we do not like, are entitled to legal representation. If you were accused of one of the most serious offences and were completely innocent, would you want to be denied that right just because ill-informed members of the public think that you are a reprehensible individual based on the offence that you have been accused of? You would want the best person to represent you to the best of their abilities. So when looking at the accusation that Keir Starmer helped free dangerous criminals, the first thing to say is that barristers in England and Wales are obliged to accept any work in which they profess themselves competent to practice at a court with which they normally appear and at their usual rates. This is known as the cab rank rule. Now, the rule derives its name from the tradition by which a hackney carriage driver at the head of a queue of taxi cabs is obliged to take the first passenger requesting a ride. The same principle applies when a case comes into a barrister's chambers, and a barrister's clerk will assign the case to the next available barrister. Now, the cab rank rule is not just a tradition or a convention. It is actually a requirement set out in the Bar Standards Board handbook, and this states that if a barrister receives instructions from a professional client, and instructions are appropriate taking into account their experience, seniority and or field of practice, they must, subject to the exceptions in another rule, accept those instructions irrespective of the identity of the client, the nature of the case to which the instructions relate, whether the client is paying privately or is publicly funded, and crucially, any belief or opinion which you may have formed as to the character, reputation, cause, conduct, guilt or innocence of the client. So if you refuse to take a case because you think an individual is a horrific individual or you simply don't like them, then you are breaking your professional obligation as set out in the Bar Standards Board handbook, and you could face disciplinary action or an investigation for doing so. Now, the cab rank rule achieves two things. Firstly, it protects that fundamental right that everyone is entitled to legal representation regardless of what they have done. And secondly, as all barristers have to abide by this rule, it removes the stigma that barristers are in some way associated or believe or support their clients. They are simply the next qualified barrister available and are doing the job with which they have been trained to do. And the Telegraph and indeed other newspapers know that Keir Starmer was obliged to take cases under the cab rank rule, and indeed in that article that I've quoted in this video, it says so right at the end of the article. But a headline of "competent barrister does job properly" doesn't sound as good as "Keir Starmer helped free dangerous terrorists," which when you think about it is actually a really sad state of affairs that we're in. And next time that you hear of a barrister, whether that's someone who is now an MP or another high-profile individual, being criticised for representing someone who the general public hate or dislike, remember that a barrister is obliged to take a case with which they're professionally proficient and are simply doing their job to the best of their abilities. And there's a further point and question I often get asked as a criminal barrister, which is how can you defend someone who is guilty? Well, the answer is quite simple. Firstly, it is extremely rare that a defendant will say, "Oh, I committed this offence, but I want you to argue that I didn't." In those circumstances, you cannot mislead the court, and it's likely that you'd probably have to withdraw from the case. You wouldn't just simply argue your case blindly on behalf of your client. It just doesn't work like that, and you'd be in breach of your professional obligations. And secondly, it is the job of the prosecution to prove the case. You are simply acting on your client's instructions and putting forward their case. But if the evidence is there, then an individual will generally be convicted of the offence. Now, very occasionally, you may get a case where the evidence looks very strong against your client, and you may have a belief that your client is guilty. But then evidence comes out in court which is completely changing of your perspective. The phrase that you should never judge a book by its cover applies here, as you should never judge a case purely on the evidence which as of yet has been untested in court, especially where you have a defendant who is saying something different. Things happen in court, witnesses can prove themselves to be unreliable, where on paper their evidence looks strong. So your job as someone who is defending your client is simply to do it to the best of their ability and to test the evidence put forward by the prosecution. But if they are guilty and if the evidence is there, they will generally be convicted. But it goes back to the principle that everyone is entitled and should have legal representation. And the fact that we have that in this country is something that we should be proud of. That's it for this video. If you do have any comments, then please post them down below. If you did enjoy this video, then please do give it a like. And if you'd like to see more from me, then please do subscribe to my channel. Thanks for watching. Take care.